Okay, I think we'll get started. May have one or two coming in. That's all right. We're keen to stick to time. So, hello everybody, and welcome to this our third and final lecture in our series of Moving the Law: Contemporary Legal Advocacy and Social Change. Welcome to everyone here in the room as well as everyone online. We've got a few joining us online from interstate as well. So, hello. I might just touch on a couple of housekeeping issues, particularly for those online and who want access to the closed captions. Just make sure if you do want to see closed captions that you click the CC icon and also select show subtitles so that you can make sure you can see the closed captions that are coming up behind us as well and hopefully appear on your screens. We will run today as a Q&A type of session where I'll be asking the panelists some questions. And there'll be a Q&A section at the end. So have a think about questions if you're in the room. If you're online, you can also post some questions in the chat in the Q&A section of the webinar. My name is Cleo Hansen-Lohrey. Perhaps I should have started with that. I'm a doctoral candidate at the law school here, and I'll be facilitating tonight's discussion. I have Tamara Wood and Patrick O'Connor with me, and I'll introduce them in a moment. Before I do so and start with our topic tonight of climate change, migration and displacement, finding new solutions in old places, I want to take a moment to acknowledge that for those of us who are meeting in the room here, we're meeting on Muwinina land, and I'd like to pay respect to the elders, past elders of the Muwinina people, as well as to the past, present and emerging elders of the Palawa people in Witwateerta, Tasmania. Before we talk about displacement of people in the context of climate change, environmental degradation and disasters today, I want to recognise the history of displacement and more the Palawa people from their homes and what has been lost as a result. When people are forcibly displaced from their homes, and particularly when that displacement is permanent, this can often have irreparable impacts on people's conceptions of home, their identity and their culture. We could talk about this a lot, but today we're going to focus specifically on one context in particular that's very pressing, and we're in Global Climate Change Week, so it's an appropriate time to be talking about this. So this is the context of displacement in the context of climate change and disasters. So climate change, disasters and environmental degradation are among the leading drivers of displacement worldwide. Displacement due to weather-related events actually triggers twice as many displacements as that caused by conflict and violence, which is a staggering figure. This type of displacement has been described by the UN Refugee Agency as one of the most devastating consequences of climate change. And of course, we know that these figures are expected to increase as climate change increases the intensity and frequency of natural hazards. In this context, effective laws and policies are essential for the protection of people displaced and ensuring that their rights are guaranteed. However, despite this, there's no framework under international law to provide protection for the people displaced in this context. This evening, as I mentioned, we're joined by Tamara Wood and Patrick O'Connor to discuss the opportunities and challenges for addressing climate mobility under international, regional and national laws. Dr. Tamara Wood is a senior lecturer at the Faculty of Law at the University of Tasmania and is a visiting fellow at the Andrew and Renata Calder Centre for International Refugee Law at the University of New South Wales. She recently concluded a project where she acted as the deputy lead for a technical consulting team supporting the Pacific Island Forums to draft a world-first regional framework on climate mobility, which is a really exciting project, and she might touch on that a little bit later for us. Patrick O'Connor is the principal lawyer and CEO of the Tasmanian Refugee Legal Service. He has extensive experience in domestic, refugee and human rights law and represents clients at all stages of the immigration process. So, as I said, we'll have a Q&A style format and we'll be discussing the potentials and the limitations of refugee protection resettlement programs and discuss current initiatives by governments in the Asia Pacific region to develop new solutions for climate mobility. Tamara, I'm going to start with you by asking if you can tell us a little bit more about climate change and its impacts generally in terms of migration and displacement and how this is expected to change in the future.
Cool. Thanks, Cleo, and thanks everyone for being here. So I suppose the first thing to say about climate-related displacement and migration, or climate mobility, which I'll use as shorthand, is that this is not a future phenomenon that we're talking about. This is something that's happening right now. So as Cleo mentioned, displacement caused by natural hazards and disasters already well exceeds worldwide displacement as a result of conflict and violence. But what it looks like is a bit different in different places. So, for example, many of us will be aware of the sinking small island states in the Pacific, islands like Kiribati and Tuvalu, which are particularly vulnerable to sea level rise and which may be expected to lose their entire territories over time. But people are already moving from those islands as the water level rises and the challenges that poses. So people are moving from outer islands to the main islands and putting pressure on more urban centres there. In Africa, it's changes in weather patterns in the context of agriculture, farming and pastoralism. Changing weather patterns mean that, previous patterns of drought and flood, which people learn to manage, have changed. So farmers may be giving up farming and having to move into cities to look for work. Pastoral communities who've always been moving to look for resources are having to take different routes, are having to move across international borders and so on. In Australia, we only got to look at the news in the last few days to see people moving, and particularly in the last few years as a result of, more frequent and more extreme weather events. As Cleo mentioned, as climate change impacts increase, we expect climate mobility to increase. And there have been some very startling figures put out there. I think in about 2010, there was a report that said 1 billion people would be climate displaced by 2050. Some of those figures are quite alarmist and based on very crude and not very rigorous sort of means of, generalising from particular situations. It's probably not likely that we're going to suddenly see, whole countries departing en masse, and certainly not, we're not going to see the entire population of Kiribati suddenly arriving in Australia because they've sunk. It's much more likely to be a more gradual process, but yes, it is likely to increase. In fact, last year, the World Bank reported that they estimated that up to 216 million people would be forced to move internally within their own countries by 2050. But they also noted that a concerted effort to reduce greenhouse emissions and to promote green development could reduce that number by 80%. So what climate mobility looks like in the future is really going to depend on what happens now and in the coming years. Where climate mobility occurs, it can take lots of different forms. The vast majority of people who move in the context of climate change will stay within their own countries. They won't move across international borders. Although, of course, if there are not opportunities at home, people do move further afield. It's very difficult, though, to pinpoint climate change as the reason that anybody moves. Climate change is often described as a threat or a risk multiplier. So it interacts with other factors, so social factors, economic factors, political factors, and in combination, these things can drive human movement. Some people will move for short periods, some people will move for long periods, some people will be able to return home fairly quickly following a disaster, for example. Some people will never be able to return home. And climate mobility will happen right across the spectrum, which we often refer to in international law, between voluntary movement or migration, so people who choose to move to pursue a better life, and displacement, so when people are forced to move. And in fact, preemptive movement can be a very effective means of adapting to climate change. And some people, in fact, research is now showing that in some areas, as climate change impacts increase, people's ability to move will decrease, because as their resources are depleted, the will or the desire to move may increase, but the capacity may decrease. So I guess the overall picture is that, yes, this is going to be an increasing, it's a current issue, it's going to increase, but it's quite particular and quite different in different places.
Thanks, Tamara. So for those who are able to move and who are able to move across borders, Patrick, it's often said that people who are able to move are fleeing climate change are not considered to be refugees in a traditional sense. Can you explain why this is the case and whether there are situations in which people fleeing climate change could be considered refugees in Australia?
Yeah. Thanks, Kate, and thanks so much for having us along to the session. Hi, everyone. Yeah, look, it's a great question. So the way the Refugee Convention works is basically 5 reasons why people flee persecution and how they can claim persecution. So, and that filters into the domestic law, into the Migration Act. So you have to have one of the 5 reasons. So as a lawyer working in this field, you're always looking for what's called the refugee nexus. And you're always making sure that every case or every hearing you go into with the tribunal or the Department of Immigration, you're making sure you're putting your case forward under one of these five grounds. And so those 5 grounds are around someone's ethnicity. So if they're fleeing persecution, that is one of the valid grounds for persecution. Ethnicity, their race, their religion, their membership of a certain social group, or their political opinion. So you under the Refugee Convention, you have to have one of those 5 reasons. Just one, but you have to have one of those 5 particular reasons. So at the moment, as part of the service, we've got many cases in those different areas. So, for example, for an ethnicity claim at the moment, people coming from Afghanistan, for example, there's a lot of conflict there, obviously, and the most common claim there is from the Hazara community, an ethnic group within Afghanistan, and they're persecuted by the Taliban, who are Sunni Muslims. So that's a very common claim, and claims that we've been successful for under ethnicity. If it was under religion, for example, we've got some claims at the moment for people that who practice Christianity, and they're from Iran, and their claim would be about their religious beliefs and that they'll be persecuted because of their religious beliefs. It could be about political opinion. We've had other claims around, for example, I was working on a case earlier in the year from Ethiopia, and his claim, he was a member of a political group that was opposition to the current government. And we said he would be targeted because of his political membership. He was posting things online against the current government. And that claim was successful as well. Or it could be, as I said, membership of a certain social group. So just finished with a client this afternoon, and his claim is around his sexual orientation. And if he goes back to his home country, he'll be persecuted because of his homosexuality. And that's based on his membership of a certain social group, which fits within that category. So generally, under the Refugee Convention, and then which is brought into the Migration Act, you have to have one of those 5 reasons. And at the moment, based on the way that the law is written, is that climate change doesn't really fit within any of those 5 reasons. It's not really about ethnicity. It's not about religion. It's not about, you're not really a member of a certain social group. It's not about race, and it's not about political opinion. So the problem with the law in that sense at the moment is that a climate change in terms of a claim for refugee status doesn't really fit within any of those 5 categories. If I can get on to the next category.
Yeah, sure. So if people who are fleeing climate change don't fit the definition of a refugee in Australia under the Migration Act, under the Convention, there are alternative pathways to refugee protection, in particular what's called complementary protection. Can you tell us a little bit about that and how in particular it might apply to people fleeing from climate change?
Yeah, definitely. So that's the potential avenue for climate change. So that basically is a secondary provision that runs right along the Refugee Convention in the Migration Act, the same area of the Act, which basically says that if you don't meet one of those 5 grounds, but you still potentially are deprived of your life, or you could face torture, or you could face killing, or you could have cruel treatment against you, then potentially you could still be protected. But there's a few factors there. One, firstly, is that you have to be found not to meet one of the main convention grounds. So firstly, you have to be found not to meet it, and then they will assess you under complementary protection. But you'll always be assessed under complementary protection if you're not found to be a refugee under one of the 5 grounds. So yeah, an example of that, how that potentially works. So about a year or so ago, I was working on a case with the tribunal, Administrative Appeals Tribunal. It was a case from Nigeria, and I knew that my refugee ground wasn't particularly strong. But the claim that the client was making was around his ethnicity, but there was a fair bit of country information to show that that a person possibly wouldn't be persecuted or wouldn't have what's called a well-founded fear of persecution in his home country because of his ethnicity. However, so I presented my case, but I knew that I had a potentially strong complementary protection argument. So I wanted the tribunal member in that sense to rule against the client for the refugee claim, because then they would have to assess the claim under the complementary protection grounds. And my case rested on the fact that the client had 3 young children, and they were white children, and there was lots of evidence at the time to suggest that there was lots of kidnappings in Nigeria in the area that he lived, and the tribunal found in our favour, said that necessarily wasn't fitting necessarily in any of the 5 convention grounds, the kidnapping, but would be a deprivation of the person's life, and therefore ruled in our favour under complementary protection. So, and where that could come in potentially in climate cases is that deprivation of life or cruel treatment of the individual. And there was a human rights committee decision in 2020 which gave grounds that potentially this could be used in the future. It was a very interesting case that came from New Zealand. So it was from Kiribati, from Kiribati, and the person had claimed protection based on the fact that they couldn't go back to Kiribati because they couldn't access any fresh water or they couldn't grow their crops. And this was a claim that was quite a well-known case. And now New Zealand at the time refused the claim and went through the court system, and then the person went back to Kiribati but put forward a claim under the Human Rights Committee. And what was interesting about that case, well, they eventually ruled in the favour of what New Zealand had done in terms of not granting any protection. There was a couple of really interesting findings in that case, and it did open up the possibility that the deprivation of someone's life or cruel or inhumane treatment could come into it, which fits within the Migration Act. And what it discussed in great length is like the time frame. For example, the committee talked at length about the fact that in 10 or 15 years' time, Kiribati could be a situation where people actually won't have fresh water and they won't have the crops and they won't be able to live. But at the moment, the ruling was it wasn't an immediate risk to the person's life. So, but what that did open up is that in time, the idea of someone having a deprivation of their life based on climate could be a possibility in the future. So that was quite interesting situations. It did open up that possibility, that complementary protection, which is connected to our overall obligations under the ICCPR, which is a convention that Australia has signed up to that could engage in someone's claim. So if I was running a case like that, that's probably where I'd be going. I'll be focusing on the complementary protection grounds, because I think that there could be some merit in that.
So it sounds like what you're saying is that there's limited potential under existing law in Australia to achieve particularly refugee protection, but there may be in the future we might be seeing some developments potentially under human rights protection frameworks.
Yeah, absolutely.
Protecting people in these contexts.
Absolutely, yeah, absolutely. And that's right. And there was some other interesting elements to that case as well, which was that potentially climate change could lead to a refugee claim in the sense that if, for example, the country is running out of water and running out of food, an ethnic minority might be the last person to be able, or group of people to be able to gain that water or food. So that could then potentially lead to persecution of an ethnic minority who might be down a pecking order in terms of being able to access the needs to live. So that was quite interesting part of the case as well.
So Tamara, given these limitations that we know exist under international refugee law, if a person can't establish they're affected by climate change in a particular way on the basis of an attribute that they possess or perceive to possess, and the limitations of complementary protection as the law exists so far, what else can you tell us about in terms of what countries and advocates are doing to provide solutions for people who have to move in the context of climate change?
Well, encouragingly quite a lot. So governments really began to focus on this issue of climate change and displacement probably around about 2010 was really when, international discussion started to intensify, and particularly around this fact that there is no instrument that deals with this issue under international law. The existing instruments that we have for dealing with displacement are not very well suited. They will cover some people, but not the vast majority. And around about that time, UNHCR, the UN's refugee agency, were like, yes, we really got to do something about this. I think we should take this on, blah, blah, blah. And a whole bunch of states went, no. We've seen what happened to refugee issues and how politicised that has become. We don't want to go down that path. We're just going to go over here outside the UN and do our own thing. Now UNHCR is involved in that, as is IOM, the International Organisation for Migration, that works more with voluntary migrants. But a group of states basically set up something called the NATSUN Initiative on Disaster-Induced Cross-Border Displacement. And it focused on cross-border displacement because that's where the main gap is. It's fairly evident if people are displaced within their own country, who is responsible for them? It's their own government. But there's a real gap when people move across borders. And the NATSUN Initiative engaged in a series of regional consultations where they went to regions particularly affected already by disasters and climate change. They looked at what was happening already and discovered actually governments are already doing a lot of things. So they found, for example, in Latin America, almost every country in South and Central America had some kind of visa on its books for temporary or humanitarian protection. So they're not obligation-based visas that you can make a claim to, but discretionary visas that governments can use to say, look, you don't fit within any of our obligations, but we realise we can't send you home, so here, have this visa to stay at least for a while. They also discovered, for example, that in Africa, free movement agreements, which to date have only really been developed at the sub-regional level, so between small groups of states, so the East African Community, for example, or ECOWAS, the Economic Community of West African States, that people were using these other migration frameworks and pathways to access territory, to find alternative livelihoods, and so on. And through this series of regional consultations, they built up a whole lot of information about what states were doing already. And from that, they produced something called the Protection Agenda, which set out, it didn't sort of make recommendations, it set out what it called a toolbox approach to addressing this issue. So it said, here's a whole lot of things that your government could do to address this issue and to provide lawful pathways, essentially, for people who have to move to enter into another state and stay there safely and access the things that they need. And the toolbox consists, I suppose, rather crudely, of two main things. One is to provide pathways for migration as a form of climate change adaptation. So before people can't even access, fresh water, you can sort of see the irony in something like the Taitiota, the human rights case that Patrick was talking about. It's like, no, you're fine to go back to Kiribati now. We know you won't be able to stay there, but it's okay for the moment. So you just go wait until the water actually comes through your front door and then we'll consider it. Now, of course, people are not going to do that, are they? So, this is about providing pathways for people like that to move preemptively or to move in order to adapt. And this can be really effective where the pathways are developed soundly and where they give people genuine opportunities and, all the associated protections. So things like the regional seasonal labour agreements that exist in the Pacific, so countries like Australia and New Zealand have these agreements to provide labour opportunities, usually seasonal ones in Australia anyway, to people from countries in the Pacific. These have not been developed to deal with climate change, but they're the kind of frameworks that can be built upon to provide particular opportunities to people in countries that are particularly vulnerable to climate change. And by giving some people the opportunity to move and to access different livelihoods, that not only provides them with new opportunities, but it can actually allow other people to stay home for longer too, because it brings, a different source of income, it reduces pressure, and so on. Things like the free movement agreements that I was talking about can also be further developed. And in fact, in 2020, and partly as a result of work done by the NATSUN Initiative and others, the IGAD region in East Africa, Intergovernmental Authority on Development, covers a lot of the Eastern Horn of Africa, adopted the world's first free movement agreement that has specific provisions to ensure that people affected by disasters and climate change can access that and that they won't be sent home even if they would usually, their visa would usually expire. So that's quite revolutionary in terms of, regional migration agreements to have those sorts of targeted provisions. The protection agenda also realises that some people will be displaced. Some people will be forced to move. It might be quite suddenly if it's a sudden storm or I was going to say earthquake, that's not really climate related, like sudden events can force people to move very quickly, but people can also be displaced by slow onset events, something like drought or sea level rise where there's the sort of creeping impacts it's very hard to decide at which point movement changes from being voluntary and preemptive to being displacement. But we do need more protection-oriented mechanisms for those people who are left with no choice. So one of the things we want to ensure is the full and robust application of refugee and human rights law. There's also work being done to further develop things like those discretionary visas I was talking about, so that there's not really the appetite to put these things onto a binding international law footing. I mean, we're not going to see a new refugee convention for climate refugees anytime soon. But work being done for states to get together in regional groupings to harmonise what they do, to adopt regional guidelines. So at least practice is a bit more transparent, it's a bit more consistent within a region, it's a bit more predictable for people who have to move. Another really more particular area that needs to be addressed is often described as planned relocation. And this is one of the very sensitive and more controversial areas. And this is where whole communities who are in an area that is going to be rendered uninhabitable, we know, in the future, are relocated from one place to another. Now, this happens quite a lot internally, but there have also been historically cases of people being whole communities being relocated across international borders. And obviously this is going to be a question in the Pacific as states do become uninhabitable. So trying to develop guidelines for how to do that best, how to learn from the, examples of where that's happened before and, do it better in future with, appropriate consultation and protection for cultural practices and histories and all those sorts of less tangible things. It's not just about having, a bit of land to live on. In addition to what Patrick was talking about, so Patrick was talking about the International Refugee Convention, which applies in Australia. There are also other refugee protection instruments around the world that apply at the regional level. And this is where I'm going to ask Cleo to share, because this is an area of her research that have different definitions of refugees that are, perhaps a bit better suited to this context. Do you want to maybe share a bit about that and about, the potential that there might be there?
Sure. It's so interesting to hear you just in such a short period of time cover such a diverse span of potential opportunities and instruments, and it's actually quite inspiring to kind of hear that again in this context as well. So as Patrick mentioned, under the definition of a refugee that we have at the international level under the 1951 Refugee Convention, a person will be a refugee if they face a risk of harm on the basis of an attribute that they personally possess. Or are perceived to possess. And that's one of these 5 grounds that Patrick mentioned. So obviously we know that climate change impacts are often indiscriminate in their nature. Now, the way that states respond to them may not be indiscriminate, and that's where we might have some refugee protection at the international level. But what's interesting is that in certain regions, in particular in Africa and Latin America, states in those regions have created regional refugee protection instruments that expand the definition of a refugee. So they adopt the international refugee definition, and they have created their own expanded definition that takes away this requirement that you be individually discriminated against as a refugee on the basis of a particular attribute. So it applies to people at risk of more indiscriminate types of harms. And so this includes things like generalised violence and conflict, and certainly in Latin America and probably in Africa, widespread violations of human rights. And importantly, for the context of climate change, people who are compelled to leave their homes because of a serious disturbance to public order in their home country may also be refugees. So this is quite interesting and provides a lot of potential, arguably, for people who are displaced in their countries across borders in Africa and Latin America to potentially be refugees in these continents if they can demonstrate that they're fleeing from events that have seriously disturbed public order, potentially in the context of climate change and disasters. So where, for example, climate change and disasters impact public order in their home state, whether or not directly or indirectly or in some way, and they can demonstrate that that disturbance is a serious disturbance, then those people may be considered refugees under these instruments. So this sounds great, right? It sounds very progressive. It's expanding on the International Convention, but it's still complex. There's not clear consensus on this position, although there is certainly growing recognition of the fact that these instruments can apply to people in these contexts potentially. UNHCR, the UN Refugee Agency, is certainly of this view. They've released guidance in 2020 stating that people displaced in the context of climate change can be refugees under these instruments on the basis that they're fleeing disturbances to public order. And UNHCR has now initiated a new research project, which Tamara and I are involved in, that are going to look a little bit more deeply at when exactly people may be entitled to refugee protection. Because it's one thing to say that they might be entitled to it, it's another thing to say, well, what is public order? When can it be disturbed? When might a disturbance be serious? Can people who are fleeing from certain human rights violations in connection with climate change, the right to life and so on, will that trigger a disturbance to public order as well as create a risk of harm to them? So there are a lot of questions that are still to be nutted out in terms of legal analysis and in terms of looking at the practice of states in their position as well. So there's still a particularly exciting project though, because it will form the basis of UNHCR's legal and normative development in this area and underpin potentially future guidance of the agency in relation to climate displacement in Africa, and which may also then inform refugee protection frameworks in Latin America and also in some other regions of the world. Because what's interesting is that we can see that in the Middle East, for example, they have a treaty that's not yet been ratified that adopts an expanded refugee definition as well that includes this public order ground. And they actually specifically, that encompasses persons who are unwillingly took refuge abroad because of the occurrence of natural disasters or grave events resulting in major disruption of public order in the whole country or any part thereof. So we're seeing quite a lot of, we're seeing that in the regions we have this sort of more progressive approach to considering the definition of who's a refugee, which may provide this greater scope for protection of people in the future. Watch this space, I suppose, maybe we'll see. But that's at least a positive note. Tamara, I'm going to come back to you and ask, because you're doing such interesting work, in particular in the Pacific, and I touched on it earlier in the introduction, and it'd be great if you could tell us a little bit more about the work that you've been involved in drafting this new regional framework for addressing climate mobility. Can you tell us a bit about that and what it means for countries in the region?
It builds quite nicely from what you were just talking about, actually. And in fact, even if we go back to the NATSUN Initiative Protection Agenda, one of its key recommendations was that the approach to climate mobility needs to be focused at the regional, sub-regional and local levels. This is not, there's such diversity in the experiences of climate change and then the experiences of climate mobility that it would be nearly impossible to even draft an international instrument that appropriately addressed that diversity of experiences. The Pacific obviously is a region that is especially affected by this issue. Particularly those small island states that are particularly at risk of sea level rise. Pacific countries have also been really outspoken advocates on the need for international action on climate change, and particularly with respect to climate mobility, but also of course other adaptation and mitigation measures. And they've actually come together and decided, under the auspices of the Pacific Islands Forum, to draft a regional framework for addressing climate mobility. And this is really exciting because this will be the first comprehensive regional framework. So there have been particular sets of guidelines on particular issues in certain regions and sub-regions, but this will be the first sort of, regional framework on climate mobility. It won't be binding. There's no appetite at all for a binding treaty on this issue, but it will be like a set of political commitments that states sign up to, and really the framework will, I say will, look, it hasn't passed yet, if all goes to plan and the vision is realised, states will commit in writing to each other and to the international community to take steps towards some of those things I was talking about before. So, to providing pathways for people to move, to access alternative employment or to, live in safer places before climate change forces them to move, to take action to, collaborate, particularly in areas where people move a lot, to facilitate, enable people to move back and forward. Often if people can just move for the dry season or for the wet season, they can stay at home for the rest of the time. And things like that. It's not only about the migration pathways, often it's the things that go around that make or break the legal framework. So, can they have their skills and their qualifications recognised in another country that will allow them to get employment, for example? Can they easily send money home to the people who are still back at home to support them and so on? The framework, I was lucky enough to be part of a small team led by Professor Jay McAdam, who's one of the world leading authorities on this issue, to draft this framework on behalf of and in collaboration with the Pacific Islands Forum. We've now finished our task and the consultations and everything and handed it over, so it will go to the political level next. The draft that we've handed over, it remains to be seen what it ends up looking like, deals with 5 different types of mobility as areas for discrete commitments and action. They're not necessarily discrete areas of mobility. Of course, there's a lot of overlap and fluidity between them, but it deals with migration, so that, as a form of adaptation. It deals with displacement, the kind of protection people need when they're forced to move. It deals with planned relocation, which I mentioned, which is that, relocation of whole communities. It also deals with evacuations, arguably, a subset of displacement, but again, something that requires quite specific actions. And finally, and perhaps a little bit controversially, it deals with immobility. So how to address the needs of communities who cannot move. I say a bit controversially, it's not very controversial in the Pacific. I think that a framework like this absolutely for Pacific governments has to emphasise that while they're adopting this framework, they're doing so very reluctantly because they don't want to move. They want to stay at home and they don't want this to be seen as, well, we give up. But of course, in other contexts around the world, helping people to stay has been not such a positive thing. So creating safe zones in conflict areas and so on. So there is still some sensitivity around whether we should, help. So we try to say we hope people stay safely at home where desired, like it's very much about agency and choice. One of the really interesting things for me, having most of my work's been in Africa up until this project, was how very, very strong the need for this framework to be a Pacific framework and not an international framework was for everyone involved in it. We're not interested in all those international frameworks. They don't have much to tell us. We're not really that interested in human rights. Yeah, sure, they're fine. We're not against them. But, for us as Pacific Islanders, what's much more important is our responsibilities, not our rights. Rights are important as the corollary of our responsibilities to each other. There were some other really strong themes that came out through the consultation and drafting process around the importance of land and culture and how inextricably linked those things are. That loss of land is not just a loss of place to live, it's loss of identity, culture, history, ancestry, everything. The need to maintain sovereignty. This is obviously a particular concern for islands that may lose territory, but for all of them as well, the sovereign right to decide how we approach this issue, to not be sort of told this is what you have to do to solve your problem. Another emphasis in there was the localisation of approaches. So not just we need a Pacific approach, but we need, an approach for Kiribati, an approach for the Solomon Islands, an approach for, and we need an approach for this village as opposed to that village. That really has to be something that's very ground up when it comes to making decisions about what to do. And the final theme I just wanted to draw out was the one of climate justice. That Pacific Island countries, with very good reason, are very keen to emphasise that though they're bearing the brunt of climate change, they, one of the regions to have contributed the least to it. And I think this is something we'll see play out at the political level as well, because many Pacific Island governments want countries like Australia and to a lesser extent New Zealand to step up and do more in relation to this. So that's, again, watch this space. I think if we think about moving the law and, trying to create new solutions and so on, this is something that is very exciting, and I think something that the rest of the world will be watching as well. What can other regions learn from this? How effective can this be?
Thanks, Tamara. And touching on other countries' responsibilities, Australia's responsibilities as a country in the Pacific region, Patrick, do you have any thoughts on what Australia is doing, what they could do to actually help to address climate displacement within our region in particular?
Yeah, definitely. I think there's some good recent examples that the government have used that could be put forward. Look, there's probably 2 or 3 things there to think about. One is the family reunification process, which is basically where someone has got, for example, a relative, if say, for example, they're in Tasmania and their brother or sister or mother or father lives in Afghanistan, for example, they have a right to try to bring them to safety to Tasmania. And under that particular visa, there's a group of visas called the XB visas, and there's a number of them. One of the categories is called the global humanitarian visa. And that visa is a lot broader than just the Refugee Convention, as I talked about before. It goes beyond the categories, and it actually focuses on substantial discrimination. And that also includes something like the inability to work as a ground for a visa. And so that is one process that could be used that's definitely broader than just the Refugee Convention, so you're not stuck with just the 5 categories. And I think the government, even in the last 12 months, if you look at the 2 major humanitarian crises, there's many, but a couple of the major ones, the Taliban takeover of Afghanistan and the war in the Ukraine. The government have leveraged a couple of opportunities there with visas quite quickly in that essence. So when the Taliban took over Afghanistan, the minister issued thousands of what was called 449 visas. So they're called a humanitarian stay visa very quickly. And that visa was very rarely used up until that point. Only a handful of visas that have been granted. It's particular ministerial power to grant that visa. You can't actually apply for it. You have to have the minister to write to you and give you this visa. Within days of the Taliban taking over Afghanistan, thousands of people, Australians who had been supported the Afghan mission, had been offered that visa and were evacuated out of Afghanistan on that particular visa. So the government used that as a leverage point to bring people quite quickly. And if you look at the example of the Ukraine, the government used a different visa category called the Subclass 600, which is a tourist visa actually, to bring people out of the Ukraine. And we got many people out of the Ukraine. So when they had a connection to Tasmania. So the scenario there was that they used the visitor visa, which is generally a visa that many people would use to come to Australia. Now, generally, that normally has a requirement under being a genuine temporary entry. It's a visa that allows people to come on a short stay period. But the government assessed that and were quite flexible around that particular criteria and allowed many Ukrainians, thousands, to come to Australia and then apply for protection when they got here on shore. So the government has a history over the last 12 months or so of using different visa categories creatively. And also, they've obviously got the powers also to add new visa categories. And I think as Tamara touched on correctly, the things like labour schemes are an area that could be used in the Pacific. And the quite relatively easily, the government can change those visa categories around, could create new visa categories, could change the policy around to create these visa categories that could bring people here quite quickly. So I think the problem with the visa system at the moment, the minister's been pretty clear about this in the last few weeks, is that it takes too long and it's too expensive. And there's a huge backlog of visas. But that could be changed. And we've seen examples, as I've said, in the last 12 months of visas being granted quite quickly for people. So I think there is opportunities for the government to use some of these levers to get people here in that scenario.
Right, thank you. I'm just conscious of time. I think I was going to recap. Maybe I'll try and recap a couple of key points from our discussion to pull them out if you indulge me a minute to do that. It sounds like from what we've talked about, we've got refugee protection visas in Australia. We have complementary protection, human rights-based visa options in Australia, and we have other categories which are sort of discretionary that the Minister and the Government of the day can decide to use if people are fleeing in the context of climate change in the future, potentially, obviously subject to government policy at the time and so on. At the international level, we have the International Refugee Convention and we have these regional instruments for refugee protection as well as human rights protections. And as Tamara touched on, a range of other free movement and other kind of frameworks and protocols that are being developed to also try and address this issue. So as Tamara said, it's no one answer, it's a toolbox approach that's being used globally, regionally and nationally to address how do we actually protect people displaced in these contexts and ensure that their rights are guaranteed. So thank you very much to our 2 speakers. I'll hand over to the audience. We may have some questions online, or if you have any questions in the room for our speakers tonight, feel free to jump in before we conclude.
I have a question.
Sure.
I'll address it to Tamara. With regard to the seasonal workers coming from the Pacific nations into Australia, how are their wages? Are they being paid the same wages as their fellow Australian workers?
This is one of the key challenges with any kind of form of migration is adaptation. So migration is only an effective form of adaptation if it includes protections around fair wages, treatment, protection from exploitation and so on. And traditionally, any kind of temporary worker scheme and any kind of migration visa that depends on a relationship with a particular employer leaves people especially vulnerable to exploitation. And there have been some awful stories from Australia and from New Zealand about mistreatment of workers under those schemes. So they're certainly not like a panacea, like, we've got one, great, look, isn't that great? It's all about the quality of the program and what people get. New Zealand is slightly ahead of Australia in that it has broader programs that allow people. So they have a kind of lottery system where a certain number of people will be allowed to relocate permanently, where they'll be allowed to bring their families, where they have flexibility to move between employers. So they have to have a job to come, but they're not then tied to that employer. And those are the types of things that provide better protection and make it more likely that people do end up in jobs that, anyone could end up in, where we have temporary schemes. Australia's are not great at the moment. But they are a start that could be built on, and if we could improve some of those protections. And look, the current Labor federal government has made sounds about developing them in the right direction. Let's see. Yeah. But, and I think this is for any of one of the really big advantages to getting yourself into the refugee or the complementary protection category, and one of the reasons that people try to do it, is that it automatically brings in all of the rights and the protections that are under the Refugee Convention or international human rights law. So you have to get all of those things. Anything outside of that does not. And that's why, it is really important that we look at the full and robust interpretation of those instruments that we look. And this changes over time as well, because our understanding of how climate change interacts with human movement changes over time as well. Like at first, everyone was like, well, refugee protection is not much use because this is indiscriminate. This isn't like governments persecuting their people. This is just, natural disasters. But over time, we've gone, actually, no, it's not. It's not natural. Like, the event might be natural, but the response is not. And that even so-called natural disasters do impact on people in different ways, depending on, disadvantage and so on. But it's because of the potential pitfalls of more discretionary migration pathways that it is so important that we don't lose sight of those, I suppose, harder obligations that states have towards at least some people. So that's a thing.
I think you had your hand up next, Fiona. So you have a question.
Yeah, I wanted to ask about, I thought it was really helpful, Patrick, what you said, those examples of sort of discretionary visas for Afghanistan and for Ukraine. So I'm wondering sort of to everyone, what's the lesson we can learn from those two situations as to what is it that tips the scales towards action, and how do we translate that to the climate scenario? I think in either of those situations, it wasn't really a movement so much as maybe lobbying from maybe ADF personnel for their former colleagues from Afghanistan. And in Ukraine, I don't know exactly what the perceived political process there or thinking was, but, is it something that Australian climate movement could think about adding to their list of demands? Maybe they already do.
I think it's a really good point, and because there's many other conflicts around the world apart from just Afghanistan and Ukraine. For example, there's a major civil war in Ethiopia that's often missed, and so it was interesting that the government moved so quickly on those two major conflicts, and were able to move particularly quickly. Within days, they were granting visas to people that had a connection to the Australian mission in Afghanistan. So they clearly can do it, and so I think where there's a real will and a need, we've seen examples of them being able to do that. So I think maybe it's something that could be lobbied in terms of climate change and something that should be put forward as a really immediate risk. So I think it's a great one.
Can I maybe just add something that I think what we're more likely to, I don't think we're likely to see like a climate change visa or, you know, sudden movement to that, but we might see it for discrete populations. So, you know, okay, we'll do this for people from Kiribati or from Tuvalu, but I don't think it'll be a, you know, I think it'll be on a nationality basis, and it probably, I mean, we can all speculate about why the Australian government responds to one displaced group differently to others. And, you know, geographical proximity, cultural proximity, historical ties, you know, and so on, will all be factors in that, I think. But I think Australia won't be able to avoid doing something for Pacific neighbours. I think, you know, that's where it's really doesn't have anyone else to point to so easily, I would suggest.
And one at the back and then Robert.
Yeah, I guess have a question about like looking at it from environmental management perspectives as well, and sort of like this need from the law though to have an immediate threat on someone's life, like that was sort of downfall you talked about in the New Zealand case. Wouldn't it be much better if we could be more preemptive rather than reactive? I don't know exactly what that would look like, and I think you talked a lot about, and it's really positive to talk about, you know, working schemes and things like that, but I just, you know, wonder if it's sufficient until we wait until those like later points.
Yeah, that's a really, really great point. And that Human Rights Committee case talked at length about this issue about immediate risk and where is the timeline? Is it 1 year? Is it 2 years? And then they decided, well, it's probably 10 or 15 years in their assessment that Kiribati will be completely underwater. And so that was too long. You know, that was their assessment. But there was a lot of debate about where that lies, because it is a future-based test, the Refugee Convention. It's all about the future, but that could be tomorrow. And I think that the analysis there that you know, where the person maybe say for a year or two, and then they're going to be have major problems was too long. You know, it was 10 years seems like a long time to wait. But that immediate risk is something that was assessed, and there was people that were in dissent saying that was too long. It's something that we should be focusing on right now, and that immediate risk is apparent in many countries at the moment.
One thing we haven't talked about, I mean, we've been focusing on migration and, you know, cross-border pathways and so on, but there's also a whole lot of work being done in areas like disaster risk reduction, climate change adaptation policies, development laws and policies and so on, about incorporating mobility considerations into all of those frameworks as well, so that, you know, disaster preparedness plans include plans to help people not to have to move if they don't want to, you know. So there is, I suppose we're talking about one part, you know, piece of the puzzle, which is when people do move, and there is a lot of work being done, you know, in those preliminary phases, because you're absolutely right. It's sort of, I mean, look, really the answer is climate change mitigation, isn't it? Like if we could actually do that well, we might not even need to talk about it, but just in case that fails, you know, let's think about it.
I mean, that was sort of my other question, but I don't want to, I mean, if it was framed as more of an adaptation, like could then that open up funding under the Green Climate Fund or like under the Paris Agreement if it was a climate change adaptation strategy rather than framed in terms of the Refugee Convention?
That's definitely going on. And the other framing that is just starting to come out is framing displacement as a form of loss and damage as a result of climate change as another mechanism for opening up access for particularly developing states to funding from the global north to support, because so far loss and damage has been, displacement and migration stuff hasn't really been part of that conversation, but that's starting to come out now and say actually having to move is a form of loss and damage, and we ought to be compensated by the countries that have caused it.
Yeah, I'm interested in how well the current sort of range of strategies that might be working in terms of work visas and things like that. To what extent is there any consideration being given to those members of communities for who are not economic contributors, who are not going to be working? So people with disability in some cases, elderly people, children, you know, do they get left behind until we come up with a better solution, or is there any consideration for those more marginalised populations, groups, people?
Yeah.
it is a real problem. It's a great point, because generally the government, when they're looking at almost every visa when they're coming from offshore, so when they're coming from outside Australia, they'll have to go through a health assessment. And the government generally will test their, what's they basically test for, are they going to cost the Australian community, specifically on money, $350,000, the assessment over visa rights. So that is a major barrier there in terms of the health assessment if someone is going to potentially cost the Australian community some funds, and that's something that's a barrier, and basically all visas will go through a health assessment. There is other types of visas, like medical treatment visas and the like, that people can potentially come to Australia on a short-term basis, but I think it's something that really needs to be addressed and is problematic here.
I think too, I think we are getting better at taking a more holistic view. Like, I think we have moved on from the international community, governments, advocates and so on, civil society. I mean, civil society's always probably been the best, but others are catching up at seeing this not just, oh my gosh, 1 billion people are going to go arrive in boats in Australia and what are we going to do, to seeing it as a bigger picture issue with lots of different components. And this was really evident in the work on the Pacific Framework, and it's why the Pacific Framework has a whole section on immobility, to recognise that, and something that's been recognised in refugee circles for a long time, which is that often it's the most disadvantaged or vulnerable communities who don't move. And in fact, when there's any kind of disaster strikes, it's usually the most socially advantaged people who move first because they can. And in the Pacific, communities are especially concerned not only about some people being left behind and not being able to access all of these solutions or approaches, but also the impact that some people leaving a community has on those that are left behind as well. And so work that is done now in migration policy and development and so on does take a bigger picture. It doesn't just look at those that move, it looks at the communities that they move from and the communities they move to, and sees that everyone is impacted. I mean, my perspective is from international law, and the role is quite limited because, international law really struggles to deal with internal issues because it comes up against the sovereignty thing, and states go, we don't want to be told what to do with our own people. When they cross a border, we can say, well, actually, you need to think about this. But so there's, it's totally not there. But I think it is something, as I said before, as we get more evidence and a more nuanced and evidence-based understanding of climate mobility, slowly our lawmakers and policymakers will catch up. What's the time frame? Will they get there? It's a separate question, but I think we are moving in that direction.
So I was going to ask, so it was interesting, Cleo, your point about the regional developments. Do you think there's a reason why the sort of quote unquote developed world seems to be so far behind in these sorts of things? So like when Cleo, when Tamara, you were talking about Africa and those like regions of Africa and Latin America. Like it seems very different from sort of Fortress Europe and the Rwanda solution that's being talked about a lot in the UK, where it seems to be going completely a different direction. Is it just because climate change hasn't affected those regions as much, or is it something more sinister sort of underpinning that sort of development?
That and you can chip in, we're almost out of time. I mean, it depends on the region that you're talking about. It's hard to sort of have a blanket kind of answer to that in many ways. Latin America, for example, is a continent that has a very strong history of giving asylum to people, actually, particularly on political grounds. In Africa, we see, huge numbers of human movement. So that's more sort of the norm in some ways. And so that sort of, from my perspective, sort of requires a solution, right? So then it sort of has resulted in states in Africa coming together and saying, well, how are we going to actually approach this issue in a way that's particular to our continent? So, I mean, this is why regional frameworks are very beneficial, because they can sort of adapt to the specific circumstances of that region. It is interesting to see developments in the Middle East, in the League of Arab Nations, for example, and the developments that are happening there. And so we can look at each region and see specific examples. But we also know that in the West, we have this increasing sort of hyper-legal perspective about trying to close borders and so on the other side, as you say. So I don't know, Tamara, if you want to add anything on that. I'm conscious of the time too, but we might just have a minute.
Maybe just briefly that I think part of it, you know, there's a difference between law and practice. So often the regions that have the most generous laws are not always the most effective at actually implementing them. And I think that also relates to just the capacity to police borders. You know, a country like Australia can be very effective in enforcing its migration law and in keeping out people who are not entitled to do it. Most countries in Africa cannot even remotely police who crosses borders. And I think this might be a nice place to finish actually, is that people will move where they want or need to move, regardless of what legal frameworks are there. So when we talk about, you know, you can do this, you can do that, it's all about what you can do lawfully. So what happens is that, you know, people move, unlawfully or irregularly. And so, you know, when I think we just need to bear in mind that there's sort of the difference between law and practice, and just, you know, countries like Fortress Europe are investing massive amounts of money in keeping people out that other countries just don't have. And so these fine distinctions of, you know, about was it really because of your particular social group or not, you know, that takes an enormous amount of resources in a country like Australia to enforce that stuff that many countries just don't have.
And I'm conscious that we haven't actually got to anybody online yet. Is there anything outstanding or pressing questions
We
there?
have one question if we have 2 more minutes from an anonymous attendee. How feasible is it to enact a program for climate displaced people to settle in rural or suburban areas of Australia, especially if it encourages development of infrastructure in these places due to factors such as increased labour in these regions?
Yeah, I mean, I think this is an issue. I mean, there was a show at Four Corners as well, talking about this issue last night actually, which was that, you know, they were showing various regional council the huge shortfall of need for medical people in those country towns, and yeah, it definitely made me think that I think there was thousands of vacancies for people, for job vacancies for people in regional towns, and it made me think that it seems crazy that there's hundreds of thousands of people wanting to come to the country through the refugee process at the moment. There's 200,000 people waiting through the family reunification process, and many of them would have skills that could work in the medical industries that would be, I'm sure, very happy to live into regional areas. And so I think we should be looking at these types of options in more detail around resettlement. There is definitely resettlement programs in regional areas, absolutely, but it's something that I think regional areas would clearly benefit significantly from, based on the information that's coming out of those regions and the need for the skills in those regions. I think there's many people that could come to Australia that would absolutely love to live in those regional areas that would provide the community with such great benefits.
Okay, great. So there's certainly some potential there for Australia to employ its, or the Minister for Immigration to employ godlike powers, I guess, to take types of things into consideration in terms of the creation of new visas in the future. And certainly we're going to see a lot of development, I think, in the future, as we've heard about today, and as we know from the news and so on, in terms of creative opportunities, hopefully, to address the displacement needs of people in these situations. We'll wrap up now. Thank you very much for everyone for attending in person and online. Thank you in particular to our 2 fabulous experts, Patrick and Tamara. And I have a few other thank yous, if you can just bear with me for a moment. We want to thank Tulls as well, who's also co-hosting and sponsoring this event. They've been fabulous with their volunteers as well in helping us to run this 3-part lecture series. Thank you to Jessie and Emily, who are our volunteers tonight, for helping us with the food service. Big thank you to Yvette and to Robin as well, our co-organisers in this series. We hope, I've just checked my list to see if I've covered everything. I think that's all the thank yous for now. We are going to have recordings of the 3 lectures that will be made available online on the university's YouTube channel, and we'll send out links to people who've registered to attend online and in person. I have been asked by our friends at the Australian Institute for International Affairs to also give a plug for a talk that is here in this room, same time, same place, tomorrow night, on Myanmar. Can foreign companies make a difference? And it's going to be former Ambassador to Myanmar, Nicholas Copper, and Professor Nicholas Farrelly from the university here, talking about this issue. So if anyone's interested, you can reach out to me and I can send you the details. So that concludes tonight's session. Thank you very much for everyone coming along.